forward to hearing from everybody.
Thank you.
Okay, Samir Jan, so we are live on YouTube and recording has just started. I think we're good to go.
Thank you, and good afternoon or good morning, depending on where you're joining us from. Welcome to session 3 of a 10-part series on the abolition of the death penalty. This webinar series is in partnership with Amnesty International Canada, Carleton University's Youth and Justice Lab, the Human Rights Research and Education Centre, the Canadian International Council, the Saskatchewan branch, the Mardoum Foundation, and the Payvand Society. Session 3 focuses on international human rights and the abolition of the death penalty. International human rights law provides a comprehensive framework for the abolition of the death penalty, although the use of capital punishment is not entirely rejected in the ICCPR. The second optional protocol to the ICCPR, 1989, aims at the abolition of the death penalty. From a human rights perspective, the death penalty is a cruel and degrading punishment violating the right to life of its victims and inflicting inordinate pain on society. This session will explore the human rights norms and mechanisms that could provide the means for holding retentionist states accountable and progress towards a moratorium and ultimately the abolition of the death penalty. Our esteemed panelists today possess a perfect blend of both the practical and theoretical when it comes to international human rights law and the abolition of the death penalty. Now, normally we would ask that the panelists speak and then we would have a question and answer period. However, our first panelist today can only be with us for the first half hour, and so we will have a brief Q&A with him before he has to part. Payam Akhavan is the inaugural holder of the Massey College Chair in Human Rights. Professor Akhavan is also Senior Fellow at Massey College and a member of the Permanent Court of Arbitration at The Hague. He's also associate member of the Institut de Droit International and the former special advisor on genocide to the prosecutor of the International Criminal Court. Professor Akhavan was the first legal advisor to the prosecutor's office of the International Criminal Tribunal for the former Yugoslavia from 1994 to 2000. At The Hague. He has also served with the United Nations investigating atrocities in conflict zones, including Bosnia and Herzegovina, Croatia, Cambodia, Guatemala, Rwanda, and Timor-Leste, and defended genocide survivors throughout the world, including the Baha'is of Iran, the Yazidi of Iraq, and Myanmar's Rohingya minority. Mr. Akhavan, the floor is yours. Thank you for joining us today.
Thank you very much, Samira, and I'm very grateful to the organizers for hosting this event at a time when we are witnessing an unprecedented assault on multilateralism, on human rights, a shrinking of the democratic space. So I cannot imagine a more important time to be having this conversation. I'm also very honored to be on the panel with distinguished speakers, some of whom, of course, are friends of many years. I was going to provide, perhaps as the first speaker, an overview of international human rights law and some of the elements that go into understanding the framework within which we have to understand the relationship between capital punishment and human rights. And Samira, in your introduction, you already referred to the International Covenant on Civil and Political Rights from 1966, which includes in Article 6, Paragraph 1, the right to life, which is obviously what is implicated when we speak about capital punishment. But before jumping to the second optional protocol of 1989, which seeks to abolish the death penalty, I think it's important to understand just how narrow an exception capital punishment is, even among those states that have not abolished it. So we should not assume that because a state has not abolished the death penalty, that it somehow has a carte blanche to execute people here and there. So there are a few elements. First of all, Article 6 begins paragraph 2, which deals with the death penalty, begins by saying, in countries which have not abolished the death penalty. So already in 1966, which was a very different space, human rights-wise, than we have today, it was understood that it was desirable to abolish the death penalty, even though the second optional protocol would only be adopted 33 years later, when significant steps forward had been taken in the universality of human rights and the move towards abolition of the death penalty. Now, the paragraph continues to say that sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crime, and not contrary to the provisions of the present covenant. So there are three important elements here. The first point is that you cannot impose the death penalty except for the most serious crimes, which typically would include, for example, murder. You could certainly not impose it for vague political crimes, for being a threat to national security, or as is the case in countries such as the Islamic Republic of Iran, for muharebe, waging war against God, whatever the hell that means. So even where the death penalty is permissible, it must be limited only to the most serious crimes. And the second element is serious crimes at the time of the commission. And this implicates the principle of legality, otherwise known as the principle of nullum crimen sine lege, which means that you cannot retroactively criminalize conduct which was lawful at the time. But it's not just about retroactivity, it's also about vagueness. You cannot impose criminal penalties in general, let alone the death penalty, for crimes that are not very narrowly and specifically defined. Because when you have crimes which are sufficiently vague, then it allows for arbitrary interpretation and application, which is contrary to the very notion of the rule of law. And in Canada and most other democratic countries, we have a constitutional principle of what is called void for vagueness. If there is a provision in the Criminal Code of Canada that is too vague to be capable of precise definition, it will be seen as an unconstitutional basis for depriving an individual of their right to liberty, let alone in circumstances where in another country such vagueness could become a grounds for arbitrary imposition of the death penalty. The further and most important dimension perhaps here also is that this penalty can only be carried out pursuant to a final judgment rendered by a competent court. Now, here we get into the question of what is a competent court. We can understand in a democratic system, competent court is one that is independent, that is impartial, and one that respects due process. Typically, the death penalty is imposed exactly in countries which don't respect due process, which don't have an independent judiciary. So in effect, if you have death penalty on the books, that is one thing. And there are a number of countries which have the death penalty in the books, but which rarely actually implement it, even if they have sentenced individuals to the death penalty. But even where you have the death penalty available, it must be reserved only for the most serious crimes, and it must in all circumstances be subject to scrupulous adherence to due process principles. Now, we have the 1989 second optional protocol, which aims at abolition of the death penalty, and we have made significant progress in the past decades in convincing more and more countries to abolish the death penalty, to the point where today there is only a handful of countries that are responsible for the overwhelming proportion of death sentences. And I refer here to death sentences that are actually carried out. And those countries, the three, by a wide margin, biggest culprits are People's Republic of China, where the death penalty statistics are not exactly clear, but there's speculation that it would be in the thousands. It is not clear exactly how many thousands of death penalties there would be. And then there is, in second place, the Islamic Republic of Iran, where in 2023, there were 853 death sentences carried out, executions. And of course, when you consider the difference in population between Iran and the People's Republic of China, you see that Iran is by a very wide margin the biggest culprit per capita in executions. And in a distant third is Saudi Arabia at 172. So that gives you some sort of overview of the perhaps the three countries which are of the greatest concern. Just very quickly, by way of wrapping up this discussion, this overview, I think it's important to look back at the idea of criminal justice. Why do we have punishment in a criminal justice system? Well, in medieval Europe, you had the idea of lex talionis, the law of retaliation, an eye for an eye, a tooth for a tooth. You still have these concepts in Sharia law interpreted by very conservative clerics and what have you. But in principle, there has been a shift away from these retributive theories of punishment to more utilitarian theories, which see punishment as a utilitarian tool for achieving deterrence in society. And in Europe, certainly, there was a progressive modernization and humanization of criminal justice, where we shifted from the spectacle of punishment in the squares of London and Paris and Amsterdam and the city throughout Europe, where there were rituals of torture, which were intended to be public, which were intended to instill fear and terror and respect for the authority of the sovereign. So that is very much what the death penalty was historically. And then through modern reforms, there was a shift away from the punishment, the spectacle of punishment, towards due process, where the criminal trial is more important than the punishment that is ultimately delivered. And some of you may be familiar with the book Discipline and Punish, which provides a good historical overview of this process of modernization. So one of the questions we have to ask is, what are the legitimate purposes of criminal justice? And leaving aside the legal considerations, even as a matter of social policy, what do we really achieve by putting someone to death? Now, one last point which I wanted to raise. In countries such as the Islamic Republic of Iran, there was, from the beginning of the revolution in 1979, a debate about a supposed conflict between what the representatives of Iran at the United Nations called secular law, as opposed to divine law. And their position was that the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, are what they called a secular expression of the Judeo-Christian tradition that, when in conflict with Sharia law, must be subordinated to divine law. That was the argument in a famous speech by certain Mr. Rejai Khorasani at what was then the UN Human Rights Commission in 1983, when there were mass executions in Iran, and it was a very unsophisticated, blatant justification of mass executions. Iran will be more sophisticated in its approach today. But this brings us back to the different justifications which exist for the death penalty, and how, in effect, the idea of universality, which was the basis for the Universal Declaration of Human Rights in 1948, the ICCPR in 1966, the Second Protocol in 1989, is exactly that these norms are universal, that they transcend different religious, cultural, civilizational norms to create an overarching set of transcendent global norms. And I will just end by saying that the playing the Sharia card, so to say, is not so much about nativism or the discovery of some authentic cultural or religious identity than it is the instrumentalization of imaginary traditions by what are modern authoritarian, if not totalitarian states. So we need to change the conversation from one of, if you like, politically correct sensitivities about cultural relativism and that sort of nonsense to basically say that this is the law and there is a reason why we have over the past decades negotiated meticulously these international instruments to define with precision what sort of conduct is or is not permissible. So with that overview, I will stop by thanking you once again for organizing this event and by once again apologizing that I may not be able to stay with you throughout to hear the other distinguished panelists. Thank you.
Thank you, Professor Akhavan. I just want to remind people to start putting in their questions into the Q&A in the chat. There are a number. There is a link to some of the UN treaties that Professor Akhavan was referring to in the chat also, and also a note here that from Amnesty's own press release this week, Iran, Iraq, and Saudi Arabia were responsible for 91% of executions in the world. If I could, I'd like to start to ask you a very sort of practical question. Going back to what you were saying about cultural relativism, how do you push back on this idea or argument that human rights really isn't universal and that, you know, to each their own?
It's a very good question, Samira, and it depends on which audience you're speaking with. Are you speaking at the United Nations? Are you speaking to people on the street, to academics, and what have you? I would say that at the international level, and this may sound pedantic, but as a lawyer, one basically says this is what the law is. And the law was negotiated meticulously by states. Iran may say, well, the Islamic Revolution had not occurred in 1966 or even in 1989, so we could not inject our vision of Sharia law in adopting these conventions. And at some stage, you have to say, well, that's just too bad. You're a party to this treaty, and international law, you cannot play fast and loose with your obligations. Your obligations are defined by these instruments, and leave it at that. But in a wider conversation, I think it's important to engage with the cultural relativist debate, because there may be circumstances where culture is very important in understanding how we interpret and apply human rights. But when it comes to the death penalty, more often than not, culture is just a pretext. We're not living in a 7th century Arabian tribal society. We're living in a 21st century. And even the means of control and repression and propaganda, which the Islamic Republic uses, is thoroughly modern. Iran is a modern state. It's a modern authoritarian state. So I think it's more the sort of manufacturing of an imaginary past to justify repression. And that's why we need to rebuke that idea and move beyond the cultural relativist debate.
I also had a question about this idea of a competent court. How do you distinguish that in international law? What is and isn't a competent court?
There are certain elements that go into defining what is a fair trial. And one of those is that it must be by an independent, an impartial court in a transparent and public proceeding. And in addition to that, one could speak in greater detail about an adequate opportunity for defense, which means that a defendant should have the right to counsel of their choice, not a counsel that is appointed by the state to parrot the position of the government. There must be access to evidence. The evidence must be aired in an open court. And the judges must not be under the thumb of the executive. So independent and impartial is both structural and substantive. Structurally, you must have separation of powers. You cannot have a judiciary that is taking instructions from the supreme leader or the president or what have you. And even in the appointment of judges, there has to be a certain independence and distance to ensure that you have judges who are independent. You need certain basis for a tenure, so judges cannot easily be fired when they don't dispense justice in a way that is to the liking of the government. But more important than anything, in a fair trial, guilt or innocence must be proved based on the evidence and based on a strict interpretation of the law. So in the context of Iran, not only do you not have an independent judiciary, especially in high-profile political trials, but the very crimes for which political prisoners are prosecuted are profoundly problematic. So, for example, muharrebe, waging war against God. What exactly does that mean? Well, it means whatever the government wants it to be in order to suppress its enemy, or mufsid fil ard, sowing corruption on earth. What exactly does that mean? So those are, even before we get to the question of due process, those kind of vaguely defined elastic crimes are always a red flag. And in a democratic society, based on the rule of law, those crimes should not even exist on the book.
Thank you so much. There is a question here in the chat. It says, for people on the street, what can be seen to be done that has effectively moved countries towards moratorium and abolition?
It's a very good question. And I like this term for the people on the street, because getting back to our discussion about law, democracy, and culture, and countries like Iran and other authoritarian states, ultimately, it's really often the people on the street that bring about meaningful change. And I'm not talking about simply shifting of power between one group of oppressive elites and another, but a genuine, if you like, seismic shift in cultural consciousness. Ultimately, democratic institutions, the rule of law, require a culture of human rights. There has to be at least a substantial proportion of society that believes in the ethos of human rights. So mobilizing social movements around human rights ideals is very important. And that includes using the media, in fact, to increase public awareness and to create a discourse which is not so much about this or that political faction gaining power, but it is about the institutions and norms that define a just society, which is also why hate propaganda, misinformation is so fundamental to authoritarianism. Authoritarian states require people who are ignorant, full of fear, full of hatred, fighting against imaginary enemies or what have you, in order to justify repression. So the people on the streets have to be engaged with these principles in a meaningful way.
There's a comment here also that says, usually high-profile cases of wrongful conviction or disproportionate application of the death penalty have also shifted popular support away from the death penalty. How much of an impact does that have?
I'm looking once again at Iran, which is the country I know most about. And now is a very difficult time because the government has dramatically increased the scale of violence, including imposition of the death penalty, including public hangings, which goes back to really what pre-modern Europe, as I explained, the idea being to instill fear and terror into people. And there have been a few very high-profile executions, not of people who are executed, let's say, for drug trafficking and the like. And even in those cases, we don't know if those people have had a fair trial or not. But we're talking about very notorious dissidents, artists, political activists, who have been put to death in a way which sends a very blatant message that resistance to the regime will carry a very big cost. And of course, this comes in the shadow of the Woman Life Liberty uprising in 2022, the so-called Mahsa Amini revolution. So the regime has been careful about not going out and killing a whole lot of people on the street all at once, knowing that that could result in an even bigger uprising, but of killing people here and there, crushing the movement, and then consolidating its grip on power by increasing the number of executions and arrests. So I think that some of the high-profile executions have played a disproportionate role in showing the people on the street why the death penalty has to be abolished.
This will be my last question because I know you have to go. You started off by telling us that it's a very horrible time right now for people who are engaged in this field of work, international human rights law. There is an unprecedented assault on international human rights law. And I'm just wondering, this might be a broad question, but how do you still tell people, don't throw the baby out with the bathwater? This is what we have to work with and we have to strengthen it. How do you still keep that message going?
Well, I will use a rather inelegant expression. When the going gets tough, the tough get going. It's really easy to be a human rights activist when you don't have to pay a price for your principles. And coming as an exile from Iran, living in the Canadian bubble, so to say, it's been an incredible contrast. In my country of origin, I've had loved ones who have spent many years in prison, who've been tortured, some of who've been executed. And then, in Canada, we haven't really, and in the wider Western liberal space until recently, we have not understood what it means to pay a price for what you believe in, to go to prison, to be beaten, and what have you. Now that is changing, in particular, given what is happening, in the United States. So I think one thing I would say is that it's not idealism is not about armchair, philosophizing, right? Idealism is about going out there, whether in the street or the academy or wherever it is that we have a voice, and paying a price. But at the same time, I would say that we are much more resilient than we think we are. When I look at the young people going out in the streets in Iran and standing in front of the bullets and the batons, I'm humbled by their courage, by their determination. So we should also not underestimate how resilient we are when push comes to shove, and also how important our voice is, especially when we join forces. And if there was any time when those of us in civil society have to come together and unify and speak with one voice, this is the time that we should be really acting in ever greater solidarity in pursuit of these ideals.
Thank you so much, and thank you for your time today.
Thank you very much, and very best wishes to all of you.
Our second panelist for today is John Packer. John Packer is an associate professor of law and director of the Human Rights Research and Education Center at the University of Ottawa. He has previously taught at the Fletcher School at Tufts University and the University of Essex. He's held fellowships at Cambridge and Harvard universities. John was the constitutions and process design expert for the UN's standby team of mediation experts advising in numerous peace processes and political transitions around the world, focusing on conflict prevention and resolution, diversity management, constitutional and legal reform, and the protection of human rights, including minorities. Mr. Packer, the floor is yours.
Thank you very much. Thanks for the initiative. Of course, it's an honor to join this panel, but especially to follow Professor Akhavan, who has not only made such a remarkable contribution in his own professional life and to the cause of human rights, but I think we could probably all just sit back and sat back and listened to him the rest of the session. It's hard to add anything after such clarity that Professor Akhavan has brought, identifying the key elements and his various references, which I think really get to the essence of this whole topic. But I'll try and add a few things. Let me say that maybe the issue that he was perhaps ending on about the coinciding element of authoritarianism with the use of the death penalty should not be lost. Who's using the death penalty and in which degree? And we see that this is, when it is for the maintenance of authoritarian regimes, then this is not even much of retribution. This is, in other words, not really about punishment of crimes as such. This is actually about extreme abuse of power and for the maintenance of the regime as such. In other words, the objectives here we should not lose sight of. And those objectives are wholly incompatible with both the letter and the spirit of international law, specifically human rights law. The UN Charter, we should not forget, not only in Article 1 and even in the preamble, includes as amongst the objects and purposes of the organization respect for human rights, but in Article 55 goes further to say that the purpose, essentially the sole legitimate purpose of the state, is to employ its resources, exercise its sovereign authority for the well-being of the population, not for an authoritarian self-enrichment or a regime maintenance. And the subsequent instruments of human rights from the Universal Declaration through the corpus that now exists, we see a further specificity. Let me draw a bit more attention to this. So Professor Akhavan mentioned, of course, Article 6 of the International Covenant of Civil and Political Rights. I'd like to draw your attention to a couple more elements of that. It's not odd that Article 6, paragraphs 2 and 3 immediately reference the Genocide Convention. It might seem a bit of a leap to go from an individual rights assertion, every human being has the inherent right to life and that should not be arbitrarily deprived. But the reference to the Genocide Convention, we have to understand, is because it's the ultimate use or usurpation of power of the state principally, but of any actor, for the not just the extinguishing of life of individuals, but is to destroy in whole or in part groups, which is a political motivation. And so I think this is not unimportant. In other words, this is not a matter of punishment. This is a matter of some other political project. This is very important because even if we look at the optional protocol 2, some people are surprised to learn it's known as the optional protocol on abolition of the death penalty. It does not actually abolish the death penalty entirely. So people are not aware that Article 2 of the optional protocol explicitly permits the maintenance or the retention of the death penalty for the most serious crime, I'm now quoting, of a military nature committed during wartime. So it actually still maintains and justifies a rationale for the death penalty. And one might ask, well, what exactly is that? Because they're not explicitly mentioned. But we know that they usually include desertion in the face of the enemy, treason, possibly espionage-related, cooperation activities, but mainly those. And what is serious about it is the consequence, again, on a social level, and it retains this not only for those serious crimes, but basically affirms that it's still a valid penalty. And I want to come to this because in a moment I'd like to relate it directly to our own country and our own country's use. So let's just spend a bit of time understanding the trajectory of the death penalty, because from a human rights perspective, it's been one of, there's been a lot of pushback the last 10, 20 years. A lot of people questioning, is human rights project a failure, and so forth. The death penalty and its development and its trajectory in terms of tendency is one of the great successes of human rights. Now today, in 1945, when the Charter of the United Nations was adopted, there were only 8 abolitionist states in the whole world. By 1966, it was considerably more. By 2015, only 10 years ago, more than half the states of the world, 100 states, are completely abolitionist. Many, many more, as Professor Akavan was mentioning, have de facto or de jure moratoria. In fact, the leading, according to the High Commissioner for Human Rights, the leading continent on the death penalty abolition movement today is Africa, where there remain a number of states that possess in their law the death penalty, but they have not actually executed anyone in quite a long time. And so you have de facto moratoria, and there's reasons for this. If we look, for example, it's already been mentioned that the overwhelming number, as far as we know, the overwhelming number of executions, whether they are summary or judicial, but publicly recorded, are in 3 states. But even the other states that have been more recently using it, again, almost all fall in this authoritarian category. And by the way, even those states which are in the last 10 years talking about bringing back the death penalty exactly reflect the authoritarian tendency. For example, Turkey is one where it's been raised, and it's not only abolished, it'd be very difficult to bring it back for constitutional and other reasons, but the fact that it's mooted and raised, it coincides not with an increasing liberty or with it's really about authoritarianism. So now, if we take a look at what are the crimes which are actually invoked for the death penalty, by far the greatest crime is actually drug-related. And this has been in a number of countries. And often it's invoked as the kind of ostensible basis. But if you look at the cases, you start to find they're not just any drug, because we have an awful ubiquitous use of drugs around the world. So it's actually using it as a facade for political opposition who may be nailed in terms of, for example, drug running to make resources that are used for other purposes. Treason, of course, remains. Many other political crimes. Terrorism, which is abusively used as a wide, arbitrary, essentially not well-defined, increasingly invoked crime. And so what we find here is something Professor Akavan mentioned, which is the arbitrariness of this, which serves whose interests? This does not serve the interests of the general public with foreseeability, with deterrence or anything like that. This is serving the maintenance of regimes. By the way, if we look then at another question here, which is the methodology of a death penalty, which has not been mentioned yet, but is an important point to mention. Because the idea is that even if you have a permissible death penalty, how do you carry it out that would be compatible with other human rights? So leave aside Article 6 or Article 3 of the Universal Declaration and so forth. Now let's look at Article 7, the prohibition of torture, degrading or inhuman treatment, or punishment. Now it becomes very difficult to actually reconcile methodology of this extraordinary, irreparable act, taking of life, with anything that would be not at least dehumanizing, degrading, and probably include forms of extreme pain and so forth. So this we know this is in detail been treated in many United States where, by the way, the moratorium movement and the abolition movement has been gaining ground, more states adding abolition. At the same time, right now, we see an uptake, in fact, even this last week, of the re-invocation or carrying out of death penalty, and by the most kind of crass forms, firing squads, for example, in places like Utah, if I'm not mistaken, where citizens can actually posture or present themselves to join firing squads again. This is quite extraordinary, but this coincides with an uptick again in authoritarianism. And what is the purpose here? If we look at the methods of torture, these include things like beheading, various forms of hanging, forms of lethal injection of all sorts of things where we get into minute arguments about how many seconds of pain and so forth. Very interestingly, in the United States of America, where there is no formal, executioner, there is the people. And you have institutions, it's the people. Faceless, there are persons who hold certain responsibilities, but quite different than in other states. Of course, shooting, as I've already mentioned, all sorts of other bizarre, electric chairs, and we could go on and on and on. And by the way, mostly these are not conducted in public. So, the old argument about deterrence and so forth, in Iran and in Saudi Arabia, they often are in public, because at least that's compatible with an argument of deterrence. But one of the problems in China is we don't know the numbers because we don't see it. Without going on about this, just to say, when you start to look at these things together, it becomes very difficult to reconcile a human rights compatible execution or taking of life. The last thing I'd like to mention is the case in Canada, to bring it home. So our viewers should know that the last execution in Canada was, I believe, in 1963. Hanging, we had a hangman in Canada. I think it was in Toronto, if I'm not mistaken. And then there was a moratorium brought in by Lester Pearson. And that moratorium actually started in 1967 on the 100th anniversary, the centenary of Canada, as a signal of progression of our society. This was a modernization, development of a civilized country. That moratorium was completed in 1973 and was then extended ad hoc until Pierre Trudeau brought in to Parliament the actual act to abolish it under the criminal code. But I want viewers to know it was a razor-thin vote. The vote was 130 to 124 at that time, 1976. But that did not actually abolish the death penalty entirely, because we retained it for purposes of military crimes and treason and so forth. So we did not actually abolish the death penalty in Canada until 1999 under another Liberal MP, Jean Chrétien. But in the meantime, which is very important to know, there was a vote in 1987 to restore the death penalty in Canada. And this was under a conservative government, but it's extremely important to know this was a government of Brian Mulroney. But they opened this to a free vote of Parliament, so not according to party membership. And the vote again was quite close, 148 in favor, 127 against. But crucially, Prime Minister Mulroney, the Minister of Justice, Ray Natishan, and the Foreign Minister, Joe Clark, all voted against the restoration. So this is, I want to underline, this is not a left or right issue. And you might remember that Stephen Harper mooted the idea. He didn't really bring back a vote. He said he didn't think the people of Canada wanted to discuss it. But he did say that he personally favored it, and he opened a kind of door. But I think he didn't bring it back. My own view is because now Canadians, 40 years, 50 years later, almost 60 years since the last execution, now, or more than 60 years, I should say. Now, I think it's a fairly deep-rooted notion that the consonance of civilized society means we do not abuse the power of the state to take life. And that's where I would like to end, that this is just not a civilized action. It's not effective. It doesn't have the deterrent effects. It does correlate with authoritarianism. It is solely incompatible with the respect for human rights.
Thank you so much, Mr. Paca. I'm seeing here there's a comment saying Harper was the first pro-death penalty PM since before John Diefenbaker.
That may well be. I think that's probably right.
Mm-hmm.
And he was not enthusiastic, by the way. Let's be fair to Harper. He said he understood that there were, I know a lot of people who have a certain understanding in extreme cases, and then it gets into a minute discussion. But Harper was not a rabid pro-death penalty advocate by any means. And so thanks to the viewer for pointing this out.
It'd be interesting to see if we put that vote again right now, what would happen. I don't want that vote to happen, but it would be interesting to see. So I have a bunch of questions for you. The first one, you talked about authoritarianism and that going with this sort of state-sanctioned murder and this manufacturing and making sure that really it's not a deterrence, it's about keeping the state in power. And going back to sort of
it's about dissent.
Yes, and persecuting of political prisoners,
Exactly.
etc. How would you apply, because you mentioned the war and the genocide convention, how would you apply these protocols to what we're seeing in Gaza today, for instance?
Well, if I'm not mistaken, I think Israel is a retentionist state. I could be wrong
Yes.
about that. It's certainly been discussed. Maybe I am wrong about that. We should check on that. But I know that there have been discussions about the use of the death penalty in the last year or so. But of course, that's assuming pursuant to law. There are some interesting questions about how extreme violence is used, force is used, and you may not have a judicial process, but for example, targeted assassinations, which are used by a number of states and seem to come in favor. I worked in Yemen for a while, a couple of years, and there were American drones used at the request of the Yemeni president. Just to be clear, this was not American foreign intervention. The Yemeni state sought that effort to assassinate Al-Qaeda and other persons. I don't know about the death penalty very clearly, extreme, egregious violence and criminal conduct has, I think, on our televisions taken place in Israel, Palestine, for a long time, but extremely in the last since 7th of October, and by many actors. I fear it's become part of the culture. I'm taken aback when the new Secretary of Defense in the U.S., Peter Hegseth, champions the idea that we're going to have, I'm quoting him now, warrior soldiers, and he champions the idea of lethality. Both my parents were in the military, and they were taught about the laws of war and about chivalry and about not harming. It was the last thing they would ever resort to and never champion was, a kind of pleasure, a desire to take life. The whole point was to defend and to secure and to protect. So I think there's something perverse occurring in the ethos of those who have means at their disposal, which is very troubling.
And briefly, just to go back to what you were talking about, drug-related issues. As we know, I think one of the statistics put here from Amnesty's own press release, over 40% of 2024's executions were carried out unlawfully for drug-related offenses. And I know that in Iran specifically, you know, most of the executions are carried out for drug-related issues. How do you prevent, I mean, how do you sort of combat that, the idea that, you know, these are our laws when it comes to drug-related issues? Particularly it was happening with opium also coming in from Afghanistan, and the United Nations was also involved in this, providing means inadvertently, not knowing that they were contributing to this. So how do you really push back on this idea?
Well, you know, Professor Akhavan correctly identified some of the other elements relating to the prescription with regard to the requirement of process, due process, and specifically with regard to courts and so forth. So we know that how we counter the risks of arbitrariness and abuse of power is by rigorous procedural requirements. And these should be of the most acute and supported form when the risk is one's life. So I think from kind of early on within everything to do with the charge, laying of a charge, to the arrest and detention of persons, the facility of a robust defense, the requirements of independent and impartial judiciaries operating under rule of law, and so forth and so on. I think what we also see is doubts in many of these countries that any of that's in place. I happen to supervise a doctoral thesis on the death penalty in China. And what we can say is that China's actually substantially improved its resort to the death penalty. For example, its own domestic requirements, it's reduced substantially the number of crimes subject to the death penalty to start with. It used to be wide slate of kind of various conduct that was disharmonious and so forth. The institutions are better informed and more independent from local sentiments and popular pressures. The requirements of, for example, review of mental health now exist and are at least subject to some apparent procedure that virtually didn't exist before. And then the actual carrying out, we're closer to knowing the number, and it seems it's probably less than it used to be for a country of 1.4 billion that has had the death penalty since ever. So I think the procedural elements are extremely important. By the way, allow me just to quickly respond to someone who's pointed out that Canada has ratified the second optional protocol, and so the death penalty can never legally return to Canada. That's not quite true, because there's a whole question about whether states can renounce. There's a whole question, there are significant questions about the character of human rights instruments. One question is whether you can have a reservation to a substantive provision of a human rights instrument. Is a substantive provision reservation incompatible with the object and purpose of a human rights treaty? But another question is whether you can derogate or renounce. And you may know that there are only very few instruments that have explicit derogation clauses. The ICCPR has in Article 4, the European Convention on Human Rights has Article 15, but most don't. And so there's a whole question about, are they totally applicable in the worst cases of war and so forth and so on? My argument is yes, they are. But the final question is, can you renounce them? And if there's no renunciation clause, does that actually prohibit renunciation? And even if there was, with due respect to the person who's noted it, what's really going to happen? You know, Hans Kelsen talked about in The Pure Theory of Law that law must have an efficacious character, must actually work. So, you know, we're seeing now countries that are, for example, 3 countries in Europe, the Baltic states, have just announced they're withdrawing from the Ottawa Convention on landmines. Obviously, we're not that happy about it, but we have some understanding for it. So I would just say that we want rigorous procedure, and we want part of that to be held, those who seek to invoke these or resort to these things, to be facing the highest scrutiny to explain what they're doing. So part of the procedural requirement is to avoid arbitrariness and abuse of power.
Thank you so much, Mr. Packer. We are going to, before we move on to our third panelist, I wanted to note that executions in Iran, as we said, account for 64% of all executions worldwide, and the majority of those are for drug-related issues. There were three women, Leila Hayati, Huriye Sabahi, and Rogaye Khalaji, who were all executed between January 2009 and October 2011. All three were mothers. All three were hanged for drug-related offenses with no due process. And I'm hoping we can get further into their stories during the Q&A. Our third and final panelist for today is Ezzat Mosaleh-Nejad, who holds a PhD degree in political economy and has been working with refugees and traumatized, including the LGBTI community, clients since 1980. He joined the Canadian Centre for Victims of Torture as a director on the board in 1992 and a staff counselor in 1997. Presently, he works with the Centre simultaneously as a settlement trauma counselor and policy analyst. He is the author of a number of books, including Torture in the Age of Fear. Mr. Mosaleh-Nejad, the floor is yours. Thank you.
Thank you very much. Please help me with yeah, thank you very much. I'm going to speak with you today on the issue of death penalty as a form of torture. Please, second slide. There's a sinister process. The entire process of implementation of death penalty has always been torturous. From the pronouncement of the penalty to the waiting period for execution of the punishment, to the very act of killing. I have one example here, if you see. This is Abdul Khalik Mahjoub, that was the chair of the Communist Party of Sudan in 1971. He was sentenced to death in a summary trial by Jafar Numeri. When they announced the sentence, he asked for a glass of water. There's nobody can take it. It's a kind of torture. The second slide, please. Limbo of death. First of all, I want to mention to you that limbo in religion is a place between heaven and hell, is a place of uncertainty, is a place of wandering, in a place that you live between fear and hope. Limbo is an existential problem of human beings, and torturers and the butchers of humanity, they know about the impact of limbo, and they use it as a technique of torture. And then the agonizing limbo of being on death row begins at the time when victims have their death sentence announced, and ends with the implementation of the death sentence. This waiting period may take from a few days to a few years. Next one, please. I want to tell you about the agony of death row. The torturer used different techniques to maximize their victims' fear. They tell them, tomorrow you will be executed. No, next week. They take them out for execution. They bring them back. They make noise. They make them feel that the specter of death is hanging over their heads. They may take them in solitary confinement, or they may also bring them to the public ward. I remember when I was in jail, and there was a gentleman who was sentenced to death, and they deliberately brought him to the public ward as a kind of intimidation to other prisoners. It was a technique of mass fear. It's torturers. Next slide, please. And also, death penalty and death row of pregnant women. The Iranian regime has killed pregnant women. And in some cases, I have one, you can see here, one lady, a Jewish lady in Shiraz, so was executed while she was pregnant. And the guard who was responsible for the implementation of death penalty said, okay, if an innocent people reside between us and the enemy, we kill innocent people. He meant the fetus. Okay, fetus is innocent, but is between us and our enemy. And he said it is legitimate, religiously legitimate. And in some cases, yeah, the regime has postponed the execution until the delivery, and sometimes after the completion of the nursing baby. Here, the child is supposed to be the messenger of life for the mother. Here, the child becomes the messenger of death to mother. It's not only torture, it shakes the conscience of human beings everywhere. Next slide, please. There is also another invention by Islamic Republic of Iran that's called conditional death sentence. They sentence the victim to death, but they keep them in jail for life. Anything happens, change of policy, change of behavior, even arbitrariness of the guard, that may result in the death of the prisoner. And as every moment of the life of prisoner is a torture. Next slide, please. And now the worst thing that has happened in Iran, and I have brought you some cases of children who were arrested and sentenced to death at a very tender age, and they lived a long time in death row, and they were executed. One example here, you can see Behmoud Shojai. He was 16 when he was sentenced to death, and he remained in death row for 15 years. Next slide. And then the psychological impact of death row and the execution of sick people. When you are in death row, you become psychologically paranoid sometimes. And when they want to take you to execution at this condition, is a case of double or even triple torture. So in 2004, as you can see here, there were five deaths, execution of death penalty of the people suffering from mental health. Next slide, please. The ancient and medieval methods of death penalty. There were horrible methods in the past that so crashing bones in breaking wheel, boiling to death, flaying, slow crashing, and killing by animals, etc. And next slide, please. You can see some of the pictures here in the next slide. Here, engraving, here, racking, and then by animals. And also, this is called brazen bull. Then they put it in a brazen bull, and then set fire behind. Burning alive, and crucifixion. But these methods, next slide, please. These methods are not used, they're rarely used today. But we have horrible methods today, like hanging. You can see in Iran, they hang people by trains, and also public hanging that is bringing Philistinism, and also no compassion, no emotion, no love. They create hate in the country, and also death by firing a squid that you can see here in the case of Kurdistan. And stoning is horrible. In my view, it's a crime against humanity because if it is against the conscience of human being everywhere, is against mainly women. They dig a pit and they bury men up to the belly and women up to the neck. And stones should not be small and should not be also big. It can take up to 4 hours for the victim to die. And there are reports of stoning in Iran in 2021 even, and beheading that you can see here in Saudi Arabia, and is degrading and is cruel, inhuman, and ironically, the job of executioner in Saudi Arabia is a very prestigious job. And also here is electric chair, and here is chamber gas. And the last one that is supposedly a civilized implementation of death penalty is a lethal injection that happened in the case of Oklahoma bombing. And many people watched. And so is also very, very painful, and it takes even 10 minutes. All techniques, old or new, ancient or modern, are highly torturous, cruel, inhuman, and degrading. Next slide, please. And I want to tell you one thing about Iran and maybe other countries. Here you see a woman, and this was painted by one of my clients who lived in a kind of cache noir called caskets for 4 months. And death penalty removes primary witness with the ghoulish tortures perpetrated against victims before death. In Iran, many women who were executed were raped because, according to a religious verdict, or whatever you call it, hadith, a virgin girl doesn't would go to heaven, and then they remove virginity and a forceful marriage and mutilation of the victims before execution. And even during Iraq war, they extracted blood from people who were sentenced to execution before the implementation of death penalty. Next slide, please. And then the impact on family, dysfunctionality, confusion, feeling of helplessness, feeling of guilt, and in some cases shame and stigmatization, and PTSD, depression. And I have also witnessed in my job suicide after a member of family was executed. Other members committed suicide. It's horrible, and it's undocumented also. And children suffer most because they don't know what happened. My uncle was a very, very nice person. Why did they kill him? And also in Iran, we have resiliency, feeling of pride in case of political prisoners, especially during the movement of women freedom and life, and also resistance. And they have mothers who are looking for justice. And the next slide, please. And the impacts on society. So the death penalty, in some cases, will result in collective trauma to the whole society. Then it might bring culture of violence and revenge. That is also not good, because if we want to build a new society in the future, we should transcend that. Fear, intimidation, pessimism, helplessness, and also Philistinism, that they don't never consider the root causes of crimes, and also they think that violence should be pacified by another violence. That is not the case. The last slide, I think. And my conclusion is that, as was mentioned by other learned panelists, international law is moving towards the abolition of death penalty. We had Nuremberg trial in 1946. They hanged 10 Nazi criminals. And today we have International Criminal Court. Two things don't happen. No torture, no death penalty. Humanity has gone a long way. And you mentioned about Article 6 of the International Covenant, second optional protocol, and also Protocol 13 of the European Convention of 2002. We are moving. And one thing also I want to emphasize, Article 2 of the UN Convention Against Torture. Torture is absolutely prohibited under all conditions against anybody. So my conclusion is that death penalty is a form of torture and must absolutely and unconditionally be prohibited. And we can use Convention Against Torture and argue in this context. Thank you.
Thank you very much, Mr. Mosalinejad. I have a question for you about the impact of the liminal state that you were talking about, this limbo of people on death row, because many of the people that I've spoken to that were tortured within Iran's prison system talked about being taken out in the middle of the night and being told that we're going to kill you, we're about to kill you, and then they don't. I'm wondering, during your counseling, have you encountered any of those anecdotes?
Unfortunately, yes. I had one client who was in death row, and they took him out for execution. And they did everything, and they shot in the air. And the impact was horrible. He became almost paranoid. Almost. Always, if anytime anything like sword or knife or even some harsh word would make him re-traumatized. So we couldn't do much for him. And we took him under psychiatric and psychological care. But all we did, we tried to stabilize his condition. And unfortunately, he remained in limbo in Canada also. He mentioned something about his affiliation with an organization called Mujahideen. And then because of just mentioning that, they kept him in limbo and no status in Canada. And it was a kind of double trauma. I had another client who also was in death row. And then finally, they commuted this death sentence to life imprisonment. But she told me that when they took her out, and 3 girls, they tied to a tree, and then they blindfolded them, and they shot in the air. And then she said, fortunately, it was raining, and all of us passed urine, and I felt that it is a trauma that never, ever went away, and it reproduces itself in my dreams. So I had another client with a similar experience. Unfortunately, in Iran, there are plenty of cases, and the impact. So here in Canada is a big challenge for our center, what to do, how to do. But I can tell you also that some clients could cope with the situation. And one of my clients who went through a similar experience, he converted his trauma into something constructive. And he's a great doctor here.
Merci, thank you so much. Mr. Packer, I wanted to bring you back into the conversation as you listen to Mr. Mosalenejad describe these anecdotes of what people that he's worked with have gone through. It just reminded me of what you mentioned about Utah. I was really blown away. I didn't know that citizens could um, volunteer to participate in this way. Could you unpack that a little bit? Because you just said it so quickly, and I keep thinking about it in my mind, and I'm sure others want to know more about it.
Well, first of all, I need to check my facts whether it's Utah or
Okay.
Idaho or it's somewhere out west
Some
in the U.S.
states, yeah.
Yeah, and so you may know that, or our viewers may not know that criminal law in the United States Federation, unlike Canada, is a jurisdiction at the state level, principally. There are federal crimes, but it's a state level principal jurisdiction, which is not the case, of course, in Canada. And so you have a wide variety of ways in which the states address these matters, and they are essentially responsible for the way they choose, for example, the means or methods of implementing the death penalty. By the way, part of the, just to say something positive before we talk about the negative side, there's been some really interesting initiatives by a number of governors in the US over the last many years, highly persuaded by, for example, the Innocence Project in the US, which tries to prove through DNA and other means and just investigations, wrongful convictions, and so forth. Part of the problem of the death row syndrome is that there are at least a lot of obstacles in the way of kind of quick summary executions in the US. And so you end up with a perverse situation where people remain for decades on the death row. Death row, by the way, has been interpreted by the European Court of Human Rights as constituting inhuman and degrading punishment in a very important case many years ago of a European who was subject to the death penalty in the US, and basically said that the non-intervention by, in terms of diplomatic protection to save them, was a breach of their human rights as a national of a European Council of Europe state. And they pled that the death penalty they were subject to was a violation of their right to life and to freedom from torture, degrading, and human punishment. I think that's a Soren case, if I'm not mistaken. So going back to the US and the governors, for example, in Illinois, the problem is the popularity or the popular attitudes around this. A lot of Americans feel that, like in China, by the way, that there's a natural justice element in the retribution of extreme violent penalty for extreme violent crime. So there's some kind of, in Confucianist terms, the harmony would be found within the community and rightness and wrongness and so forth. That's a kind of Chinese logic. But in the United States of America, it's kind of more simplistic, nostalgia of the West, and but also kind of tough, honest people on the earth. This is justice. You do a bad thing, you pay with your life potentially, and of course that has a popular appeal. But anyone who's responsible for this and looks at it in detail realizes it's not so simple, and it's hugely incompatible with lots of things. So a number of governors bravely have waited until their last moments and then have commuted en masse persons on the death penalty. Illinois is an interesting state to look at in this regard, because I think it was like 20 years ago that one of the governors just commuted 170 or something people on death row. And then it took the next governor to actually propose, it began a conversation, and the next governor proposed, or two governors later, an actual abolition bill and so forth. So this is part of the trajectory. Now, unfortunately, in some states, just to get to your question, unfortunately, where there is this popular sentiment to it, and then there is kind of I don't want to say an anxiety, it's more like there's partly a moral anxiety, but there's an intolerance or an impatience around all the arguments about injections and which ones work and which ones don't work. And so they go back to a very simple thing, the people. And they say, well, straightforward firing squad works. You stand the guy up and you bring him before the citizenry. And now the question is, well, who does it? So there are two things very important about this in a firing squad, which are a little bit perverse. One is who actually has the bullet or the bullets. I think in the last ones this last week, there were 3 lethal bullets. But very often in the firing squad, you have a number of people and they have dummy bullets, and only one person has the lethal bullet. And they distribute the lethal bullet in a lottery. So the point is, nobody knows who actually fired the lethal shot. And this is to create a distance in the citizenry from possible retribution, for example, from families of the person who's executed, but also this kind of personal. So there's a gap of responsibility under the shade
maybe
of
remorse. Is that part of it too?
No. I've read and been told that people who participate in this kind of thing, if you shoot a dummy, you're shooting a dummy. So they probably know, but the society doesn't know. This is the point. And so this is what. But the other side of it is, who signs up for this? And of course, so they make an open call. Who wants to do justice for the bad people? And it's all projected this way: the torturers, the rapists, and so forth. Which very often we are talking about serious criminal conduct. There's no doubt about it. But I think it's a kind of perverse thing where socially people kind of sign up to kill their fellow citizens, to be blunt, under the guise of judicial process, legality, and justice.
There was a comment from Omid Milani, one of the organizers, who said that execution by firing squad and stoning, public stoning, share significant similarities, so that in both methods individuals may participate directly in the act of killing. And I know in the stoning case in Iran, the idea isn't, they really regulate the size of the stones, because the idea isn't to kill you in 1 or 2 shots. The torture is the point.
Well, my understanding of stoning, and I believe there was a stoning case in I forget the governorate in northern Nigeria a few years ago. This very much depends on the interpretation. I know nothing about Sharia really, so I don't know what's prescribed precisely. I doubt the size of the stone is prescribed. I doubt the strength of the person throwing the stone or the exact distance from, but I do know that there have been different methods. Some persons have been tied to poles, some have been dug into pits. I mean, when you go, so I have actually investigated actual executions, for example, in Afghanistan. I was present the day after a public beheading in Jalalabad when I worked for the United Nations, and I investigated that case. And it was a case where there was a Sharia process that was, and the penalty was applied. It was a person who had murdered a brother of another person. And there were, to tell you the story short, it's reported in a report by the United Nations Special Rapporteur on Afghanistan from about 1993, probably. And what happened is there was an effort both to have not only a proper judicial process, but even a clemency before the general public, because I understand that it's a higher calling, that if the people would, first of all, if the aggrieved family would pay blood money or accept blood money instead. I mean, there are different other procedural elements. But when it came to the actual execution, it had to be done by the aggrieved family. So the brother of the person who had been killed was given an axe in the public square, actually intersection of 2 roads. And, with all the nervousness and with no physical constraints. And so there were some Norwegian humanitarian workers and others who witnessed it. I wasn't there for the witness, but I took testimonies of people who were afterwards. And apparently it was a gruesome thing that took many, many efforts. And And there's no way anyone could say that this was done with humanity, with decency, without suffering or pain, with any dignity, neither of the immediate victim nor any of the participants. So, by the way, we concluded it was Afghanistan permitted the death penalty for the most serious of crimes. They did have a process. And so we said, okay, well, the death penalty per se may not be prohibited, but we couldn't imagine how you actually do this in a way that would be ultimately compatible with the requirements of human rights.
That's quite horrid. There is a comment here in the question section. Maybe I can make it into a question, but it says, torture and execution has its roots in violence caused by hate and intolerance, which in power finds its chance to act. It's something that goes beyond only the governments. It establishes a culture. The people in these countries usually carry the same hatred of the same government. This culture is a very important outcome of torture and execution, which needs to be addressed. Does anyone want to take that on?
Yeah, I think that's a very relevant and excellent comment. The issue why one person tortures another person. The moment you are a human being and I'm a human person, so there's not you are not others. You extend your humanity to me, I extend to you. I cannot torture you because you are me, I am you. But the moment you become enemy, or you are, for example, you believe in one religion, or I believe in another religion, you belong to a tribe, I belong to another tribe. So this kind of hate, this is very important. The logic of exclusion should be replaced by logic of inclusion, by love. That love is on the top of the board. It is of universal power. The main issue when we want to fight against torture is not only going for legal instruments or calling governments into account, or so addressing impunity. These are all good, but more than that, we need to work very hard, and we have a long way to go to just produce, encourage a culture of peace, a culture of nonviolence, and pacifying violence by peaceful means, but nonviolence is very important. The culture of enlightenment, the culture of inclusion.
There is a question here about again, sort of people to people as executioner. And I don't remember which of you said this. Oh, I think it was you, Mr. Mosaleh Najad, that the job of executioner in Saudi Arabia is something that's quite prized. Whereas in Iran, if I recall, their faces are hidden. It's you really don't know who's doing the executioning. There's a question here about the involvement of medical personnel in the United States, for example, in the process of the death penalty. It says Florida's lethal injection policies call for a warden to select personnel with sufficient training and experience to perform the technical procedures needed to carry out an execution by lethal injection, listing professions such as paramedics, EMTs, nurses, physicians. The American Medical Association says in its Code of Medical Ethics, a physician must not participate in a legally authorized execution. What do you make of that?
In 1982, there is Principles of Medical Ethics, is a non-binding part of international law. So medical personnel, either doctors or nurses, should not get involved in torture directly or indirectly. And in Oklahoma case, the people who did lethal injection, they were not medical personnel, and they are police officers trained to do their job. And that is why it takes a long time for the victim to die. It's not done professionally. And I think Charles Dickens has a aphorism saying that law is an ass. You can take it anywhere. But unfortunately, in the case of torture in Guantanamo Bay and Abu Ghraib, medical personnel in the United States were involved. And there was also involvement of American Psychological Association, and it was very, very unfortunate. But we continue to push for medical personnel and not to be involved in torture in any sense of the term, because it would set a very dangerous precedence. And also we are looking for abolition of death penalty. So by using, and all methods should be stopped. The death penalty should be abolished. Even lethal injection is horrible and cruel, inhuman, and a kind of torture.
Anything to add to that, Mr. Pecker?
Well, yeah, this kind of odd preoccupation with it's kind of a twisted logic to convince oneself that one is being not only just, but also humane and civilized. So, the idea of unnecessary suffering and pain, even if historically, the laws of in war, humanitarian laws, it's sometimes called, and so forth, have rejected this. You render someone hors combat, in chivalrous combat. If they are no longer capable of participating, they are to be protected, and so forth. This goes back a long time, and certain instruments, methods of warfare were prohibited because they were considered to be odious, and just not fair, but not decent. And so there's this element that's we're trying to reconcile. How do you conduct the death penalty? It's very interesting to put this together with the firing squad because, as the last speaker was just saying, it's very hard to find doctors and others who will actually participate when scientifically they know what's actually going on. And even if it's a matter of pressing a button to release the flow of the whatever is the lethal injection, what's technically happening, they're participating, and that's contrary to either their oath or their conscience or anything that they otherwise would present. So that becomes problematical. So interestingly enough, the firing squad, which someone has drawn to our attention, in Britain and elsewhere, it was long ago rejected. It was retained in some US states, or one or two, for quite a long time, or for almost ever. But in the last 10 years, a number of states have returned to the firing squad. I don't know what the number is now, but it's at least a half. I mean, the case of firing squad execution the last couple of days was in South Carolina, I believe, in South Carolina. So they brought back the firing squad. And I think part of it is this kind of public,
That's wild.
Well, this public desire for kind of participatory retribution, something like that, and the kind of wild, I don't know what is the logic, but part of it is they're giving up. They're kind of throwing up their hands and saying, you know what? All this scientific mumbo jumbo, we'll just shoot the guy. and it's that kind of, it's almost giving up on the essence of the civilized or decent element.
Wow, that's amazing. I can't even fathom that's happening.
I think it's 5 to 10 states now have it, if I'm not mistaken. And by the way, quite interestingly, some years ago, a viewer might correct us, there was a whole interesting case where someone opted for the firing squad, someone subject to the death penalty. And I can't remember what the rationale was, because I think they didn't want to be suffering to the injection, or they were tired of death row or whatever. I think they said, oh, just shoot me. And they did, I think.
I'm going to ask if you could if you'd like to make some closing remarks on international human rights law and the abolition of the death penalty. If I could start with you, Mr. Mosalinejad, is there something that you'd like to impart before we close this session?
Yeah, I have three major points. One, when you go to international law, is based on intergovernmental agreement. I have been in some UN session. You should satisfy all states. Most conventions are products of compromise. So then what we need is we need a movement, a human rights movement at the very grassroots level, the way you do at Amnesty International. The second point, when we speak about abolition of death penalty, abolition is not adequate. We should go far beyond abolition because there are some states like Israel or Russia. They don't implement death penalty in a de facto way, but the way they do so, they commit all sorts of crimes, war crimes, genocide, crimes against humanity. We need a humanitarian and humanist agenda. So we should push for that. The third point I want to make is about impunity. You mentioned about closing their eyes or so they don't want public to know. I think impunity should be addressed as both macro and micro levels. Even the people who torture with the direct order from the above, they are also accountable.
Thank you so much. Mr. Parker, do you have any closing arguments, or not arguments, but any nuggets of wisdom you'd like to impart before we close this session?
Thank you for the opportunity. First of all, thanks again to the organizers who initiated this, and to yourself also, Samira, for your excellent moderation, and for the viewers. I mean, in my career, such as it's been now for many decades, often in the face of the dark side of our human condition, a lot of bad things happen, and it's unfortunate how our species is capable of doing very nasty things, and individually we are also. And I've had the unfortunate, but maybe particular experience of not only taking testimony from victims, but also testimony from torturers and others. And a person, one of the people on the chat, reminded me of the often mental health challenges of persons who participate in executions. And we know that in the context of war, when persons are forced into conditions of war, they often face also PTSD and so forth, because it's kind of unnatural, inhuman. I mean, I know it's ubiquitous through human history that we do these things, but on an individual basis, we try to live, we try to protect and preserve life. And so to take life is somehow deeply contradictory of our instincts, our nature. And then to do it in conditions where we have such control and power and purposefully seems the height of kind of perverse conduct. And I'd like the viewers to leave with the thought that the use of the death penalty is not about the, I won't use the word victim or perpetrator, the person being executed, the subject. It's a question about ourselves. I think, it's the looking in the mirror, who are we? What is our society? And it's not a there but for the grace of God go I question, my own personal, it's a bigger question. Is this civilization? Is this very fundamental moral questions about being and the nature of relationships and so forth? And I find it difficult to reconcile the death penalty, whatever the arguments are of utilities and whatever, which I think there are very few. I think when you pick them apart, they all fall apart. But I find the basic thought of it unreconcilable with living a righteous and decent life, was supported by any kind of moral code. It's about us.
I think that's really a great way to talk about, the death penalty as almost holding a mirror to who we are as humans, not necessarily, putting the blame on this government or that authoritarian, but really taking a good hard look at ourselves and what type of society we want to be. I believe, Mr. Musali Najat, you have a book launch event today in Toronto. Is that correct? You have a book coming out, The Right to Life.
Yeah, I with Mr. Raisi, we
Shameless plug here.
yeah, we have jointly published a book entitled "The Right to Life and Against Death Penalty" with Mr. Raisi, and we have a book launch today. It is in Farsi. Farsi language. It will be at 6 p.m. in 5110 Young Street. The location is North York Community Memorial Center. Everybody is welcome.
Great. So that'll be in the Persian language.
Yes.
Okay. Perfect. Thank you so much. I also want to remind everyone that the next session is on May 10th, and it is on the abolition of the death penalty and political violence. Thank you again to all of our panelists and to all the organizers. Take care.
Thank you. Bye. Bye.